industrial dispute resolution in RTE public service in Ireland. I will start remembering some of you and inform the others about the regional forum in Ireland held late January and hosted by RTE in Dublin. This forum was aimed at decision makers in public media service companies and examined regional approaches and strategies in a climate of cutbacks and media market change in that deep and long economic crisis. So the public broadcasters, especially regional challenges with budget cuts for programming and wages, and less investment in technology, layoffs, etc. During that summit, as Michael Lally wants to call it, well, also known as Mikey, there were several presentations made by Paul Doyle, Michael Lally, Glenn McCarthy, Theo Valtinen, as I pronounce it well, Gerard Schutman, Tone Kunst, Christina Agren, Olaf Carlson, who was here, yeah, he's here. And during that presentation, we together get experience about what are the things and strategies that are doing those public services in different countries, and especially focused on their regional strategies. So Michael gave us overview of regional strategy. Paul Doyle talked about the balance of regional presence and cost efficiency. Glenn McCarthy talked about the smart technologies and for the new regions and implementing of the new technologies and cutting costs. Theo was talking about reshaping the regional structure. Gerard talked about the public and politics force, how the public and politics force public service media to the biggest changes. Tone Kunst she was talking about the restructuring of future audience, and Christina talked about adopting demographic and technical map of regions, and Johan Linder was mediating that, and Olaf Carlson also present a part of that adopting new regional structure in Sweden. So we will start from that, and now I give a word to Mr. Peter Doyle, CFO of RTE Ireland.
Thank you, Mela. Just by way of slight clarification, I'm not actually the CFO of RTE. I am the Finance Director with specific responsibility for regulatory and corporate affairs, which means that in effect the sort of stuff that has been the subject of some of the earlier presentations in relation to the threats to the public broadcasters from competition, in relation to the developments of public regulation and the attempts by the public broadcasters to resist being confined in their role to the type of service that has a limited audience and a limited interaction with the public. That is very much the territory that I'm involved in on a day-to-day basis. Prior to taking up that role, I've been involved with the news and current affairs operation in RTE for many years, and previously with the television programme making area, while in both cases in financial roles. It does mean that what a lot of you are about in terms of journalism, in terms of programme making, is not entirely foreign territory to me, and I do try to understand you from time to time, and hopefully you'll try and understand me. In particular, the additional context of my appearing here is that, as well as my formal role in finance, I am a management representative for RTE on what we call our Industrial Relations Tribunal, which is a form of dispute resolution which we find has worked very successfully. And when I was meeting with a number of your colleagues at the summit that Mila referred to, I had just come from a long night conciliation session which had proved successful, and in talking to Johan in particular, it appeared that there was quite an interest among this group in how we approached what is a problem for, I imagine, many of you. So that's the context in which I'm appearing here. I was going to start off, but I can't actually get it because of the come up on the screen because of the connections, with simply referring to the second and third top headlines that you would see right now if you accessed RTE's news website. Well, it's just dropped from top, but it would have been that the first one was that the Troika, which is what we call the joint EU, ECB and IMF group that is monitoring our bailout, a term which will be familiar to a number of you, I'm sure, is calling for the strict implementation of the 2013 budget measures in many sectors, and stating that sustaining Ireland's fiscal performance is key to durable market finance. So that gives you an idea of sort of the overall economic climate in which we're operating and where we're coming from. The second headline I'd give you by way of context is that we are stating that another public sector organisation, the National Bus Company, is about to be closed down by industrial action and strikes this weekend. So that's the sort of overall context. We're a small, open economy. Our broadcasting environment is characterised by significant overspill from broadcasters regulated outside of the country, particularly broadcasters regulated in the United Kingdom. Our national languages are Irish and English, and because effectively the entire population has fluency and familiarity with the English language, the effect of overspill broadcasting from broadcasters regulated in the United Kingdom is extremely large and accounts for a very large proportion of television audiences. As I'll indicate later on, this becomes particularly relevant in the context of our capacity to generate commercial income, and in particular the fact that a number of these channels operate extensive localised opt-out advertising in Ireland, which is not subject to the level of regulation that either the public broadcasters or even the Irish-based private broadcasters have to deal with. We entered early into the world of bailouts, restructuring and economic crisis, or as they call it in the parts of the world where it's more distant from them, the global economic crisis. In 2008, we hit serious difficulties following the collapse of an artificial boom which had been largely driven by inflated property prices, an oversized construction industry, and all this largely fuelled by borrowing, which was unsustainable and led to a situation where the main financial institutions in the country were on the verge of collapse and had to be bailed out by the government, thereby rocketing the national debt to a vast multiple of the GNP. and bringing about immediately on foot of that the intervention of the IMF, ECB and EU. So our overall economic environment for the last number of years has been characterised by the bailout, by austerity, which is the term used to refer to a combination of increased reductions and cuts in all areas of government expenditure and increases in a wide range of personal taxes, thereby significantly reducing disposable income, the consequences of which for broadcasters should be apparent or will become apparent shortly. The environment that we're in, there are two public broadcasters, ourselves, RTE, and TG Car. Both organisations are represented in the delegates here today. RTE operates a number of television services, radio services, free-to-use online services, and maintains orchestras and performing groups. If I can just divert for a moment to talk about the funding model for RTE. It's not unusual in its fundamental nature, but it is unusual in the extent and the mix of revenue sources. It's a dual-funded broadcaster in that it has both public and commercial revenue. However, from the very inception of the station, the view was taken by the government of the day in the 1960s that the Irish economy was such that the level of licence fee that would of itself sustain a public broadcaster would be too heavy an imposition on the public, and that equally well the size of the Irish market made it impossible for a broadcaster at that time with a public service remit to be wholly sustained by commercial revenue. So we've ended up with a dual funding mix which is approximately 50% commercial and 50% public. That puts us, I think, very much in the higher end of commercial dependency of European public broadcasters. And that creates a situation of considerable volatility, which has had particular effects in recent times with the decline in the economy. The economic impact has involved a major fall in our capacity to generate commercial income. This has been driven by a number of reasons. The recession, which has had both direct effects in the fall in disposable income, but also it has the psychological effects in that there's an increased savings ratio in the country. People are afraid of what's going to happen next. They're afraid of losing their jobs or afraid of significant reductions in their earning capacity. Therefore, even people who have money don't actually spend it. Needless to say, this is a fact that is very well known to advertisers. And as a result, many of them, in fact all of them, have significantly cut their spend across all media aimed at the Irish market, including in particular television. We have also seen over the last number of years increased penetration by the foreign regulated channels selling local advertising opt-outs. Most of them operate on a very, very low cost base insofar as the programming, largely consisting of licensed programmes and repeats of old programming from other channels, is of very, very little cost and is run for both the United Kingdom and Ireland. and they have the facility to run opt-outs in their advertising, and that has been eating into the amount of advertising available both for the public service channels and indeed the commercial channels in Ireland. So RTE has been faced with the necessity to dramatically reduce its cost over the period since 2008. Operating costs have been reduced by in excess of 30% since 2008, and we are committed to ongoing cost reductions going forward into 2013. The types of cost reductions that we have engaged in have been wide-ranging and across the board, because at this kind of level of reduction you can not afford to ignore any aspect of the service. So it has ranged from agreeing with our unions and our staff a voluntary reduction in salaries, through to reductions in the amount of programming commissioned from the independent sector, through to reductions in our spend on sports rights, and a vast range of cuts and renegotiations of individual service contracts and provisions. And to come to what was mentioned earlier on and the context of our discussions in Dublin, we sought in the course of last year to identify opportunities for restructuring our infrastructure of regional studios and news gathering facilities to one which is more in line with current technological requirements and current journalistic practices. And we have done that through the development of partnerships with institutes of technology in various parts of the country. Where are we today? We're involved in a multi-annual review of the adequacy of public funding for broadcasters. That's currently in progress. We await its implications, but the one thing we know is that an expectation and a requirement from us is that we will continue to commit to significant cost reduction programmes and continue to deliver efficiencies in our services. Notwithstanding the constant theme of lack of funding and the constant pressure to reduce cost and reduce spend in all categories, we still have, as previous speakers have said, we still have to remain relevant. We still have to stay in the media space. We still have to appeal to our audiences on all media, including particularly we have to continue to keep pace with the developments in new media, because, as stated previously, if we don't do that, ultimately as an institution we don't survive and probably don't have a reason to survive or a mandate to survive. So now I'll come to what I was really asked to talk about, which is our particular mechanism for resolving industrial disputes. But I'll briefly just show where that fits in terms of delivering on our overall service plans and our overall financial plans. As with all broadcasters, labour costs are a very significant part of our cost base. We are under the constant requirement from our regulators to achieve and to demonstrate the achievement of efficiencies in the use of all our resources, including labour. There is a public expectation that there will be a continued and seamless delivery of service. So therefore, the kind of situation that I mentioned with other organisations where they're looking at significant withdrawals of services as a result of strikes and industrial disputes is one which we feel would be unacceptable, difficult, and would place us in a serious position with our regulators, who would be inclined to say, well, we're not actually delivering the service. So In that context, there's agreement between both the management and the unions representing the staff that we need to resolve our issues without resort to industrial dispute. But that is in an environment where there are real and serious issues that need to be addressed in order to achieve the efficiencies. It's probably rather coincidental or interesting in an Irish context that I'm talking to you about industrial dispute resolution mechanisms this year, because this year is actually the centenary of the largest industrial dispute in the history of Ireland, which took place in Dublin in 1913. That was old-fashioned industrial relations. I think, and I hope, and I think I can confidently say, we've all come a long way since then. Background to our own particular approach and our own particular mechanism. In 1992, we had an all-out strike, as it was described as. By all-out strike in the sort of Irish usage of the term, it means that all unionised staff were on strike. This arose from a single issue, which may seem rather bizarre looking back on it now, but it was a very real issue then, in that it was the introduction of two-person electronic news gathering crews. But I do mention here this is 1992 we're talking about. The strike lasted for 6 weeks. During that period, RTE maintained pretty much a skeleton service with a large amount of repeat programming, with a large amount of acquired programming, and a minimal news service provided by members of management. This was at a time that actually saw a major political crisis in the country with the fall of a government and an election. Quite simply, if the same thing was to happen again today, I have very little doubt that as an organisation we would not survive. The public and the government would not accept that a public service broadcaster could be running with such a minimalist service for such a length of time. So in many ways, what developed in response to that situation proved very advantageous, because without a mechanism for avoiding that kind of situation, I don't think we'd be talking to you here today. The dispute was eventually referred to what's termed the Labour Court, which is a statutory institution in Ireland that seeks to resolve industrial disputes. It's a joint body, but it operates under law and has considerable powers to make recommendations in relation to the resolution of industrial disputes. They obviously recommended a resolution of the actual substantial issue in dispute, but it was also very clear to them at the time that the state of industrial relations in RTE was very fraught, and in fact there was a regular procession to the Labour Court in relation to relatively minor issues going on at the same time. So they recommended that sorry, I've actually skipped a slide there. Sorry, they recommended that there would be a joint review of the employee management trade union of the current industrial relations practices by a joint management and trade union consultative procedure within RTE. Now, sorry to bring it back to the slide you've just been looking at. So the task of that was a joint group was set up which was to evaluate and recommend possible improvements on alternative processes. Pending the outcome of that report, a group was established at the recommendation of the Labour Court, which was called the Special Adjudication Committee. The Special Adjudication Committee, its original terms of reference were actually laid down by the Labour Court itself. Firstly, it was limited to issues arising from technological change and from changes in work practices. Now, that's a limitation which didn't continue in subsequent structures. It had equal representation from the management and the trade unions and was chaired by an independent party chairperson who was agreed by the parties. It was free to determine its own rules and decide if an issue that it was dealing with was a suitable issue for it to deal with. It was allowed to seek to secure agreement between the two parties. It was required to have full regard to all relevant agreements and practice in existence at the time, and it was very much seen as being an additional stage and not being a substitute for normal internal negotiating machinery within the organisation. The joint review recommended the establishment of an industrial relations tribunal. What were the differences between that and the original temporary structure? Principal ones were that the remit was no longer confined to issues of technological change and work practices. And secondly, that there was a facility for the addition of additional members. It also provided for the group to act in a conciliation role. Originally, that was relatively low-key, but it came to be a very major part of what we do. It had the power to issue both binding and non-binding recommendations, though the circumstances in which to do so would be different. It was characterised by a constitution which was agreed by the employers and the unions. The constitution dealt with a number of issues. It dealt with membership. It dealt with the process by which disputes could be referred to it. It addressed what kinds of issues would be the subject of binding recommendations and what kind of issues would be the subject of non-binding recommendations. It set out the scope of what it could deal with, and it dealt with the capacity to conduct conciliation and mediation. It also laid down the procedures, and most importantly, it introduced a clause that there would be no lockout by the employer or no industrial action by the trade unions at a time when an issue was properly before the tribunal. So if I can go through the main elements of it now. The first element of it is the composition. It has a permanent chair who is agreed between the employers and the unions. It has a permanent management representative, and it has a permanent trade union representative. That's the three of us there at the moment. It's not a beauty contest, as you can see. But in addition, when it's dealing with an arbitration or a judgment as distinct from in its conciliation role, it has an additional 2 temporary representatives, one from the union and one from the management, usually people who have specific interest in the issues or knowledge of the issues before it. The process is that, first of all, there must be local negotiation. And the local negotiation, if it doesn't produce a result agreed between the parties, either one party or both parties jointly will refer it to the tribunal, who will first of all seek to conduct conciliation, in which they assist the parties to reach agreement between themselves. Failing that, it proceeds to a full hearing at which it will issue a judgment. There are a number of conditions for the referral of an issue to the tribunal. First of all, it can deal with issues referred by either the employer or by the union or by both of them. Each party must submit a statement of the efforts they've made to resolve the issues at local level. The tribunal must be satisfied that these local negotiations have been meaningful, and on occasions when they're not satisfied, they will refer them back to do more work locally. I mentioned binding and non-binding recommendations. A binding recommendation is given where it's an issue of technology or an issue of work practices. All other issues, the recommendations are non-binding. If either party is not satisfied with a binding recommendation, they must implement it, but they can refer it back to the tribunal for review after 6 months in operation. If either party rejects a non-binding recommendation, they must notify the other party within 30 days. What we deal with? We deal with anything that's properly brought to us by the parties, but what we don't deal with and won't deal with is we don't deal with individual issues. We deal with group issues, not individuals. I mentioned conciliation and mediation. Originally, this was just a provision in the Constitution, but it's actually become very, very important. It's significantly expanded since it started. It's conducted by the 3 permanent members without the assistance of the additional members, and there can be parallel discussions, plenary sessions, proximity discussions, and in fact pretty much anything necessary to help the parties reach an agreement between themselves. If it fails, then the next step is to go to a full hearing. If we have a full hearing, there's a written submission sought from each side. The 2 additional members are added, as I mentioned. The case is presented by both sides to the tribunal, who have the capacity to ask questions. When the hearing is finished, the tribunal will deliberate and will then issue a decision. Now, if I just might talk a little bit about the way it actually makes the decisions, because this is actually very important and is probably key to its relative success so far. We'll make every effort to arrive at a decision by consensus. If we don't, it can be done by a majority decision. If there's no majority decision, as, for example, if, say, the union representatives and the management representatives have diametrically opposed views of the issue and there is no middle ground between them, the chairman himself makes the decision. But the really important thing about it is, irrespective of how the decision was reached and irrespective of whether the individual member agrees or disagrees with the decision is always presented as having been the decision of the full tribunal. So once a decision is made, every member of the tribunal is part of that decision and must stand behind that decision, irrespective of what their personal view was, once it's been properly made. As I mentioned, important thing in keeping the show on the road, in keeping the service delivered, is there's no industrial action when matters are before the tribunal, and neither can there be any lockout by the employer. What does it deal with? Anything from local work practices to new technology, to scheduling of personnel, to incremental pay increases, to eligibility for membership of pension schemes, and work practices in wider areas. So pretty much anything that can be an industrial relations issue, as long as it's not an individual issue, can be dealt with by the tribunals. Recently, we have, as a result of the economic situation and the fall of commercial income, there have been two broad initiatives introduced by management. The first one, if you see on this side, a wide-ranging document of guiding principles of how a number of issues ranging from remuneration to work practices would be dealt with, and scheduling and leave and various things. This went into negotiation, and the negotiations, after a certain time, did not reach a result. It was referred, I think originally by management, to the tribunal, and went into a conciliation process. At this stage, something fairly interesting happened, because it became clear that there were two groups of issues. One was a range of guiding principles which affected pretty much every unionised worker in the organisation, and the other was issues to do with rostering, which affected approximately 400 staff within the organisation, but all concentrated in a particular area. So it was agreed in part of the conciliation process that the two streams of negotiation would actually split out and would become two separate conciliation processes. And they went through those conciliation processes and eventually reached the stage where, in both cases, after protracted late-night sittings, agreements were reached between the parties. And because these are not work practice issues solely, they're the subject of a ballot, and they're currently being both agreements are currently being balloted on by the unions. At the same time, on the right-hand side here, management sought to introduce a wide-ranging change in the work practices of people in the television operations area, television technical grades. Again, that went into negotiation. The negotiations did not produce result, and it was referred, in this case again by management, to the conciliation. In this case, the conciliation process did not produce an agreed result. Sometimes it works, sometimes it doesn't. This time it didn't. The parties were too far apart to reach an agreement. So it was then referred to a full hearing. And because it concerned work practices, the full hearing was going to be in the form of a binding recommendation. That hearing took place. The deliberations of the tribunal took place after the hearing, and it is currently, the binding recommendation has been issued to the unions and the management. I can't tell you what it is, because one of the practices at the moment is that when a binding recommendation is issued, both parties have 14 days to take account of it before its results are made known. So, does it work? What's the record? Oops. This doesn't work. Sorry. Action eventually. Well, first of all, since it came in, we haven't lost any days of service through industrial action. As a public service broadcaster, that's important. Most disputes are resolved, not necessarily to the satisfaction of either party, or in some cases both parties, but they are resolved. We have not had very much recourse to outside resolution processes. We have had one or two cases since it came into place that went to outside bodies, but very, very few. On the negative, it can be a very, very slow process, and particularly for those who are seeking to introduce change and are looking to achieve a change, it can be seen, particularly the conciliation process, as extremely long, extremely drawn out, and not be seen as a barrier to introducing change, but be seen as certainly something that can delay it. Clearly, the other risk or downside to it is that in the case of non-binding recommendations, there can be rejection by either party. And I suppose the final issue would be that solutions often fall short of the aspirations of both sides. Now, I've put that in as both a positive and a negative. Because initially it sounds a negative because you've got two groups of people who are dissatisfied. But on the other hand, it may be inherent in the process that if a process like this is to work and is to be successful, that you'll often end up in a situation where neither party is wholly satisfied, but both parties are satisfied enough to get on with doing business together. So, in conclusion, thanks. Initially, it was imposed on RTE and its unions by an outside body, the Labour Court. It was an alternative to external conciliation procedures. It successfully has eliminated industrial action. It works, but it depends on the active support of both the employer and the unions for it to work and for it to continue to function. So it may not suit everybody. It certainly has suited us, and it has been a useful part of doing business in our organisation. So thank you for listening.
Thank you, Paul, for your presentation. Do we have some questions from the audience? The lady.
Could you be more specific about what kind of action you are talking about? It's how does an employer at your station feel this? What kind of things are you doing?
Well, I mentioned two of the largest recent cases that we're dealing with. The one that went to the binding decision affected pretty much all the workers in the television studios areas in terms of the work they would do, the demarcations that would have existed between different grades in terms of whether certain grades would do certain kinds of work or whether certain other kinds of work would have been the preserve of other grades. The other element that was agreed by negotiation, by conciliation that I agreed to was about the rostering of staff in the studios and operational grades, and it would have changed their rosters, which would have a significant impacts on both the hours that people would work, the notice they would get in relation to the hours they work, and also from management side, the flexibility of work practices and consequently the capacity to get savings. During the course of the last year, we've dealt with issues such as the rosters of journalists, the detailed work practice of orchestral musicians and artists, which is a world unto itself, and a range of issues ranging from small issues within small groups right up to issues affecting very large groups of workers. So possibly since its inception, I would say pretty much every group of unionised workers within RTE has at some stage had some part of their work practices or conditions of employment addressed either by agreement and conciliation or by a binding decision of the tribunal. And possibly every area of management that works with unionised groups has also been involved in decisions that have been driven through this process.
What kind of changes did you do so that we can feel if, compare with our own companies to see where we are compared to where you are? When you say they have to change working hours, what does that mean? When you change the roosters, what does that mean? If you could be a little bit more specific.
We would have had a 78-hour fortnight for operational staff in studios, but this was referred to as in RTE as the 13-point roster, because there were 13 sets of individual regulations that dealt with when people could be scheduled within it, when they could start, when they could finish, how many days they would have to get off back to back within a particular period of time, how many long weeks or short weeks they could work. It's obviously with 13 different rules in it and various permutations in the day. It obviously covers a very wide range of individual situations. The agreement that was arrived at by conciliation changed some significant aspects of that. It changed to effectively moving from each 78-hour fortnight has been seen as individual and standing alone to a position where there was a kind of a rolling period over rolling 4-week periods in which numbers of days of unworked hours or overworked hours could be carried forward. What's the significance of that? Significance of that from the management point of view would be that situations where overtime would have had to be paid to people because they exceeded their scheduled hours in a particular fortnight, but could well have been as a result of changes in programme demand being underutilised in a subsequent week. That the introduction of those new patterns would change that overtime working. That obviously had consequences for the individuals themselves. So you may ask, it was agreed by negotiation, what was in it for the staff? The kind of thing that would have been in it for the staff was that as part of this, they got longer notice periods in terms of when they would be rostered. So now that's giving you a very short summary of what was in fact a very complicated agreement, but those are kind of the highlights of what would have been involved in it.
Any more questions? So, as we all saw on that beauty shot, you are personally involved in those negotiation and conciliation. So, what is your experience of doing that?
Well, I'm the permanent management representative on it. I'll say I've been on it for approximately 3 years. I've found it an extremely useful and, in fact, rewarding experience because ultimately, in most cases, you come to some sort of a conclusion. You feel you've done a job. You feel you've got a result. Say you're not always going to be popular, and if I find that difficult, my trade union colleague probably finds it even more difficult. But you always feel that you produced results at the end of it. So yes, it's quite a good thing. Yeah.
Okay, thank you, Paul. If you don't have any questions, we will conclude this session. Are there any questions or comments? No? Okay, thank you.